Yeah, the numbers are rising, so it is sharp 2 p.m. and I would very much like to welcome you back after this lunch session. I really hope you had a relaxing time and enjoyed the breakout rooms. This is one of the things that we unfortunately cannot have the real life experience of meeting up during lunch, but I think so far this conference has been going tremendously well. And I think we covered, everybody can hear me? Yes. Good, fine. So far, I think we have covered a lot of ground this morning and we have listened to great presentations and a wonderful discussion of the key issues already. And I would like to now welcome you to our third session, and that is the European-wide view of experiences and instruments. I think we have already discussed different legal approaches. There came in very interesting comments from different sides, and this against the background of the CRPD. And it has shown that the approaches are incredibly different and that there is a great diversity. And we are now going to dig deeper into this, taking a comparative perspective, and then also taking a look at the private international law perspective, because with the increasing mobility across Europe as well as international global-wide, the divergences between the different systems do become obstacles, and we are also having to deal with that. And then we are finally going to take also a look at the CRPD from quite a different perspective, and that is the dialogue and the Swiss experience that we will hear something about. So I'm very happy that we are having such eminent speakers here for our topics for this session. And I would like to first introduce Adrian Ward, who is going to speak about the comparative overview. And who could do so better than him? He has a long international record as expert and also campaigner in the field of rights policy and practice relating to people with disabilities. And I don't think really it is necessary to introduce him. He has published widely in many countries and many languages over the past 3 decades. And many of you will know his book, The International Protection of Adults, which was published by OUP in 2015. But he has not only published in this area, he has advised governments and international organizations, and most importantly, in our context, as a consultant to the Council of Europe, he completed and published in 2018 a review of implementation of the Council's recommendation on principles concerning powers of attorney and advance directive. So he will be particularly able to tell us about this topic. Our second talk will be on the 2000 Protection of Adults Convention. And here we have also a most eminent speaker, Philip Lorty, first secretary of the Hague Conference on Private International Law, whom I equally don't really have to introduce. He joined the Permanent Bureau of the Hague Conference in 2001 as first secretary, and he has been, and this is particularly important for us today, primary responsibility for the 2000 Protection of Adults Convention. Moreover, for a number of other conventions like the Child Support Convention and the Protocol on the Law applicable to maintenance obligations. And he's also has joint responsibility for the international Hague network of judges, including direct judicial communication and the judges' newsletters. So we have been talking about the interaction also of the judiciary, and this is here in the international field. Before that, he acted as head of the Canadian delegation already to the Hague Conference. And I assume also in that role, he was already involved in the convention and its drafting. And ultimately, and not last but not least, I would like to introduce for our third topic, that is the CRPD and adult protection and dialogue between the Swiss, about the Swiss experience. That is going to be presented by Michel Cotier, whom I don't have to introduce as co-convener of this conference, and you already saw her talking. But I'm happy to say that we have her on board as the Swiss expert with FL-EUR, where she is able to bring in her tremendous knowledge and expertise, which she has recently, most recently, proven by her two big national science foundation projects. And her presentation is together with Dr. Caroline Hess, and she brings in a totally different but very fascinating perspective, which is so important to take into consideration, as we have already talked about this morning, because she is head of the Equality Department and at the same time Deputy Managing Director of Inclusion Handicap, which is the umbrella organization of disabled people's organizations in Switzerland. And she's also research assistant at the chair of Professor Markus Schäfer at the University of Basel, who enlightened us this morning with his talk. And she lectures frequently and has also published extensively on in this field of law. So having introduced our four speakers for our three speeches, I would like to now give the floor to Adrian. Please go ahead, and I would like to welcome you all, and please, Adrian Ward, the floor is yours.
Thank you very much, Nina, and good afternoon, everyone. I'll just start with a comment on something we heard at the beginning of the day, and if you want to talk more about it, we can do that in discussion later. I join this eminent academic gathering as an outsider from a background of 50 years as a practicing lawyer. I was first asked to lecture on this topic, what became our subject, in 1976, and it didn't exist as a subject. It's still a very new subject, albeit a new subject with a long history. And I would suggest that any impression that we have a shared objective is just because we're in a very preliminary stage. What shocked me back in the beginning was to realize in modern terms how far we fell short of what 30 years later became described in Articles 12.1 and 2 of the Disability Convention. In reality, we still live in a world where theory tells us there's a presumption of capacity, and practice far too often everywhere demonstrates a presumption of incapacity. So I'll just leave that thought with you and move on. As a practitioner, I constantly sought the best practical solutions amidst the huge variability of individuals and their circumstances. Each time, how best to strike an optimum balance between autonomy and protection. Were special measures needed? If so, what measures? What measures were available? Were they good enough? Often they weren't. So one pressed the boundaries as far as they would go. If that was not far enough, one pressed for law reform, then became involved in the process. Such development required comparative research to support arguments and to develop reforms. Thus, I became aware at an early stage of both the great linear variability over time in any one jurisdiction and the great horizontal variability across jurisdictions at any one point in time. But those other jurisdictions were also in their own process of linear development, in many cases accelerated now by the Disability Convention. The result is a huge dynamic variability across our continent. One cannot do justice to the 9 words of our conference title, comparatively across all the jurisdictions of Europe, in a short presentation. So I'll describe functional categories, the menus from which practicing lawyers endeavor to select, with an emphasis on the basic point that comparing only 2 jurisdictions, particular measures that may have the same level, the same label, and seem to have similar packaging, will almost certainly have significant differences once you open the package and look at the detailed contents. That variability is multiplied across our continent, with further variabilities arising from reforms of hard law and developments in practice as to how the law is applied. That variability becomes acute when an existing measure established in one jurisdiction is imported from that jurisdiction into a receiving jurisdiction, and we seek recognition, operability, and enforceability in the receiving jurisdiction. On terminology, I use the one word measure. Older international instruments refer to measures of protection. More recent ones, notably the Disability Convention, to measures that relate to the exercise of legal capacity. There we have the 2 starting points of protection and autonomy, which need to be balanced in each individual case, but with the main emphasis shifting from protection to autonomy. That shift is still driving processes of law reform, as well as influencing interpretation of existing law and of international instruments. There are 3 principal categories of measures, 2 of them divided into subcategories. They are voluntary measures, which can be bilateral or unilateral, non-voluntary measures, which can be automatic or established by a court or other authority, and third-party measures. Relevant human rights principles indicate that priority should be given to rights to autonomy and self-determination, so that voluntary measures established by an adult should be preferred to non-voluntary measures created otherwise than by adults themselves. The terms voluntary measures and non-voluntary measures have generally superseded the former classifications of anticipatory measures and responsive measures, a change that reflects the shift from a binary world of capacity or incapacity, sanity or insanity, educability or ineducability, and so on, to recognition that these extremes were the theoretical ends of a wide and diverse range of characteristics and capabilities, with no one completely capable or completely incapable. Unilateral voluntary measures are addressed to the world. They're probably all encapsulated within the definition in Council of Europe Recommendation 2009-11. Advanced directives are instructions given or wishes made by a capable adult concerning issues that may arise in the event of his or her incapacity, which may apply to health, welfare, and other personal matters, to economic and financial matters, and to the choice of a guardian, should one be appointed. Bilateral voluntary measures are essentially contracts of mandate, authorizing someone else to act, if and to the extent that relevant capacity of the grantor is impaired. There is variability for almost all of the key features of advanced directives and such contracts of mandate, and in their states of development and levels of use. advanced directives are particularly undeveloped across Europe. There are other unilateral and bilateral techniques, often very simple ones, such as unilaterally making gifts or bilaterally setting up a joint bank account that can remain operable by one account holder when the capacity of the other is impaired. Largely undeveloped are provisions maximizing support for the exercise of legal capacity in the very common situations of variable, fluctuating, or gradually increasing impairments of capacity, principally by including provisions for support and co-decision making operable independent of questions of capacity. The interplay of advanced directives and powers of attorney, whatever the terminology, and using both in combination, offers scope still largely undeveloped. I give examples in my pre-recorded lecture. Non-voluntary measures are those put in place by a court or other authority, or designated professional, or by automatic operation of law. Yet again, we have to note great variability in what exists or doesn't in any one jurisdiction. The purpose and scope of particular measures and, more subtly, which measure might be preferred in any particular situation. Non-voluntary measures may also be addressed to functions under other legislation, such as health, and in particular mental health legislation. Third-party measures are measures including trusts established by the provider of funds or assets. Beware that the categories of measures that I have described cannot be put in neat, self-contained boxes. One category may incorporate characteristics of another. As a final web of tripwires, similar measures may be described by very different terminology, and similar terminology may be applied to very different measures. It follows from all that I have said that great care is needed in addressing apparent similarities between one jurisdiction and another. Drill down, and similarities on the surface may well conceal significant underlying differences. The task of dealing with this can be fascinating and rewarding. Thank you.
Thank you so much, Adrian. That was a wonderful, given in a nutshell, the comparative overview, so to say. And beforehand, I was wondering how you would be able to do it in 10 minutes, but bravo. And I think you already came back to a lot of the issues that we have been dealing or touching upon, and also your warning regarding the terminology, and that is something that we will have to really keep in our minds, and we will, and the great variety that exists when we are going to embark upon our FL-EUR project, or we are already in the middle of it. Thank you very much. And with that, I would like to continue on with Philip Lorty, please, on the 2000 Protection of Adults Convention. And may I at this point already say that if you have any questions or anything that you want to raise, you can already put them in the chat, and I will follow that, and then we will do the discussion later on. So please, Philip Lorty, the floor is yours.
Yes, thank you very much. Thanks to you for the introduction. Thanks to the Institut de Droit Comparé and FL-EUR for this, and the University of Geneva for this invitation to talk to you today. And thanks also for the introductory words of Adrian that would be useful. As you can imagine, I also will talk about terminology, as I actually touched upon the point this morning. I would share my screen for a presentation, and that is actually a shorter version of the the presentation that you'll find on the website about the 2000 Hague Convention. The presentation on the website that you can consult at any time also includes an introduction to the Hague Conference on Private International Law, which I encourage you to go and listen to know more about the organization. But with the allocated time, I will limit myself to the 2000 Convention. So yes, indeed, I was involved in the negotiation of the 2000 Convention. I was representing Canada in 1999, and I was also part of the drafting committee. Mind you, I don't remember everything we discussed in the drafting committee. Sometimes we have questions that arise, but thank God we have proceedings of the negotiations that we can go to and consult on a regular basis. So the convention predates the UNCRPD in 2000. But this being said, the convention actually is one which has a lot of, I think, elements that would actually make it complementary to the 2006 convention. Certainly, the 2000 Convention on the Protection of Adults gives effect to Article 12 in a cross-border setting. It will actually support the adult in his or her legal capacity in a cross-border setting. The 2000 Convention supports vulnerable adults in exercising their legal capacity across borders. The convention in its preamble, and I think it's very important to note in its preamble at the time in 2000, affirms that the respect for the adult dignity and autonomy are to be the primary consideration. So certainly when I see dignity and autonomy, it certainly includes wills and preference in my view. One has to read a convention text in a very liberal way, especially one that deals with important human rights, such as these ones. You have to give it, as much sense as possible and give it as broad scope as possible when reading it, applying it. The 2000 Convention provides for the protection in international situations of adults who, by reason of an impairment or insufficiency of their personal faculties, are not in a position to protect their interests. Back in 2000, this is the way we would express things. Now that we have the UNCRPD, maybe we would express things a little differently, but in no way are there contradictions. These two treaties, as I said before, are complementary and they support each other. So in very quick overview, I'll give you a sense of what the 2000 Convention does. Basically, it provides for what we call rules of private international law. In doing so, it will avoid conflicts between legal systems of the contracting parties. It does so in different ways. And I'll give you two examples. A young adult has a ski accident, falls into a coma outside their jurisdiction. And regrettably, we don't know much about this person. This person is alone, not accompanied. They don't have powers of presentations with them, nor do they have advanced directives. They're in no circumstances can one actually know what their wills and preferences are. And it happens. It's a very rare case, but somebody will be assisting them in how they go about, coma, repatriated in their own state, which probably would be their wills and preference. One can actually presume that, where they would like to be cared and to have actually be surrounded by family and friends. Another example is one that we actually experienced in the last few months. People were in induced coma further to COVID, and there were actually overflow of intensive care units in some states, and decisions were taken to actually transfer temporarily patients into other countries. And this is also an example of application of the convention. So how will it work in those circumstances is the convention provides for jurisdiction rules. So which actually states competent authority can actually have jurisdiction at a time on a specific subject matter, and they will take a decision. And that is the first rule of private international law, jurisdiction. The second rule is applicable law. When that competent authority will take a decision, they will have to apply a law. In most circumstances, under the 2000 Convention, the law that will be applicable is the law of that jurisdiction, or what we call the law of the forum. And once you have a decision, this is the third part, recognition and enforcement. When you have a decision, there are rules in the convention that will actually facilitate recognition and enforcement of the measures taken in all contracting parties that are connected to the subject matter in question. The convention also provides for to give effect to powers of representations. We are of the view at the Secretariat that this also includes advanced directives, certainly advanced directives that are part of a power of representation. The convention, through the rules of applicable law, like for a contract, will give effect to those powers of representation in the different states concerned. And finally, the convention provides for a system of cooperation, which is operated by central authorities that are designated under the treaty or convention. And these central authorities are have specific tasks that are provided for under the convention, that they have to actually provide services, be it, finding the whereabouts of an adult in another state, providing information on the law applicable to another state, or to facilitate mediation in some matters. So the convention also provides for party autonomy, some party autonomy in relation to jurisdiction. So it will be possible for an adult, before they become vulnerable or incapacitated, to decide on the jurisdiction that they would like to actually be seized in resolving legal issues that concern them once they are incapacitated. And it will also be possible to actually make a choice of law out of a selection of laws. You cannot just decide any laws. They have to be laws that are connected, substantially connected to the adult. Those laws that would actually should not raise any concerns or disputes once a dispute is initiated. They should be straightforward and provide for legal certainty and predictability. So this is how the system is it works. You'll see in this slide all the different types of measures that are actually covered by the convention. This is not a closed list. This is an open list. You see, there's just about everything. Competent authorities can, determine incapacity or not, put institution protection regimes in place. It is possible to also designate a representative to the adult, or somebody who will be assisting the adult. You see, I underlined the words guardianship and curatorship. I touched upon those earlier this morning. I think that we have to be open-minded about this terminology. First, this treaty will not be amended. It is quite an undertaking. Guardianship here will include what we referred to this morning as traditional guardianships. It will also include modernized guardianship or proper guardianship. And I've heard Professor Marcus Scheffer's last intervention this morning said that, well, maybe we should, get rid of all these names and come up with new names. I think that we have to be also respectful of the different legal traditions. In some civil law states or legal systems that are driven through the philosophy of deduction, yes, you can sometimes come up with new concepts and put them into law, into a code. In the common law jurisdiction, it's a different story. They follow a philosophy of induction. And what usually happens is that a concept, guardian, will remain, but what constitutes guardianship will evolve. that's proper to common law. And as we heard and saw this morning, most of the states that have actually modernized their system, keeping that word of guardian or guardianship of our states of common law tradition, like British Columbia or also Ireland. Scotland is a separate animal in itself, as it follows mostly civil law, as we know from Adrian Ward. So I think that just to conclude, it's important to remember that the convention actually builds bridges. It is extremely respectful of the differences of the different legal systems, the different legal traditions. It in no way does the convention actually intends to harmonize substantive law. This is not our role at the Hague Conference. Quite to the contrary, we will actually provide solutions for the different actually systems or concepts to work together. And this is where we say all states today should all be parties to the 2000 convention. You don't need to wait for your legislation to be actually reviewed or modernized. It would be applicable now. It would be applicable now, and it's in the interest of adults, because we think that is better to have some kind of solution in